My name is Paul Carelis. I lead the HR services team here at MP, and welcome to today's session with MP and in coordination with NELA. Today we'll be talking about key practices for reducing legal risk and exposure for transportation companies. For those of you who are new to MP, we are a full-service human capital management and HR company. We offer services everything from payroll to HR, benefits administration, time and attendance, and compliance. We serve clients in all different industries and all different areas of the country. If you'd like more information about us, feel free to check out our website. Quick legal disclaimer. This training is intended from an HR best practices scenario. I am not an attorney. We will be talking about some legal matters and compliance items, but please don't construe anything presented today as legal advice. Should you have any questions at all throughout the presentation, feel free to use the Q&A feature within Zoom. With that, we will kick things off. So in terms of what we want to talk about today, we'll go over kind of some of the best practices for handbooks here in 2022. We'll do an overview of the most important kind of basic employment laws and statutes that trip up employers, especially in the transportation industry. We'll discuss the importance and the application of job descriptions when it comes to managing your workforce in a compliant way. We'll discuss compliant hiring practices, I-9 forms and eligibility, as well as the pitfalls of misclassifying employees. One quick note, we'll touch upon some state law, especially here in New England, and where things differ, but most of the topics we're going to be covering today will have a kind of a federal lens through them. So when it comes to those federal laws, at a bare minimum, there are several that employers need to familiarize themselves with because they can be the subject of lawsuits, discrimination claims, what have you. First of which is Title VII of the Civil Rights Act. So this is the basis for many harassment claims or discrimination claims that you see in the workplace. And when you hear the term protected class, most commonly, unless it's at the state level, and obviously states have larger and more inclusive lists of protected classes, this is the first and original set of protected classes: sex, race, color, national origin, and religion. So something you have to be mindful of, that none of your business practices, none of your personnel decisions or anything like that are made based on any of those protected classes that you see on the screen here. Another one that a lot of people aren't aware of, so many people do understand the notion of protected classes and the Civil Rights Act, but one that a lot of people aren't aware of is the ADEA, or the Age Discrimination and Employment Act. So while technically it isn't illegal to discriminate based on age for people who are under 40, once someone, an employee or whomever, does reach the age of 40, they are protected by this act. So you do have to be mindful of that. There are certain requirements that come along with the ADEA, among which is if you use a severance agreement or a release of claims, if you're terminating someone and in exchange offering them a severance for them releasing their claims to a lawsuit or anything like that, just a common severance agreement, there is specific language that you need to have in there to comply with the ADEA if the person being terminated is over 40. That includes a 21-day period for them to consider the agreement. So you have to give them at least that long to decide whether or not they want to agree to it. And then there's also a 7-day revocation period. So once they do sign it, they then have 7 days to change their mind. There also has to be language in there that allows them to or encourages them to speak to an attorney about the agreement. So if you are using a severance agreement and the person that you're giving it to is over 40, just make sure you have the necessary language in there for that. Some other ways that this comes into play would just be, reasonings for counselings, questions in the interview process. So even for people who you haven't hired yet, you just want to be careful, especially when it comes to things like talking about technology and things like that, where you might make an assumption that someone who's older might not be as computer savvy or something like that, and which isn't necessarily the case at all. You just got to be very, very mindful of this. This can oftentimes trip employers up. ADA is more and more relevant as the days go by. So Americans with Disabilities Act prevents employers from discriminating against people based on their disabilities, and really creates what's called the interactive process. So if you presume, or an employee comes to you and mentions a disability or their inability to do something, well, you really have to look at the job description, which we'll talk about in a little bit. But it all comes down to the essential functions of the job and whether or not those can be done with or without reasonable accommodation. So the interactive process is just that, where an employee might come forward with an accommodation request. You don't necessarily have to accept that accommodation request. It is truly interactive, where if that accommodation is going to create an undue hardship on the company, then the company can propose their own accommodation and have some back and forth there. ADA is being used more and more, especially as employers who have an on-site setting and want the employees to report back to the office, post-COVID, after working remotely. There have been a lot of ADA claims and interactive process there, and that's become quite a hurdle for many. In the transportation industry, there are some outs. Obviously, if someone is hired as a driver or operating a motor vehicle, and they lose that ability, either lose their license or lose their vision or whatever it may be, there isn't really a reasonable accommodation when that can be made to allow them to perform the essential duties of that job. So there are more outs than in the transportation industry than some others, for sure. Next is USERA. So this protects folks who are veterans or in active duty. So it does provide leave, job-protected, unpaid, but job-protected leave for folks who are in active military and need to serve, whether that be in the reserves or called to active duty otherwise, and creates other protections against discrimination because of people's military membership. Then there's the IRCA. So this protects folks against discrimination based on national origin or citizenship. So again, something you want to be mindful of, especially with interview questions and opportunities for advancement and things of that nature. And then lastly, another one that's been more topical and more popular over the last several years is the National Labor Relations Act. So this governs a lot of things. The main purpose of it was to create a set of rights for employees in attempts to unionize their workplace. So definitely a lot in the news about that now, between Amazon and Starbucks and all the unionization efforts there. So while union membership is ticking up, that's on the heels of really several years, if not several decades, of declining union membership. So the way that the National Labor Relations Act has remained relevant in those times is creating those rights that, even if it doesn't necessarily pertain to employees making active efforts to unionize, that it's protecting their rights to talk about their working conditions and things like that. So they've delved into things like handbook policies, whether those are chilling to employees' rights, social media activity, if employees are discussing via social media with one another some of their working conditions or complaining about something. Sometimes those are found to be protected under the National Labor Relations Act. So even though its main purpose was to be rules around unionization, it applies to many other circumstances as well. So not something you can necessarily ignore even in a non-union environment. terms of handbooks, we often get questions about what the best practices are for this year. And some of these are evergreen and some of these are more relevant this year than in previous. The first thing we always like to hit home on is that employment at will is an important thing to have in your handbook. You want to be sure that your handbook serves as a guide and a tool and an introduction and into enforceable rule book for your policies, but you don't want it to create any sort of implied contract where as long as someone follows those rules, they guaranteed employment. So it is important to have an employment at will statement in your handbook and mention it throughout in anything that's starting to sound the least bit contractual. Nowadays, for employers who are able to do it, if you do have expectations and rules around remote work or a hybrid work policy, the handbook is a great place to address those. We also feel that while larger employers will have like a Family Medical Leave Act policy as required or leaves of absence, a lot of times we see it missing from smaller employers' handbooks. And generally our advice is to have something in there. It doesn't have to be too specific, but just talk about if someone requires a leave of absence, to present that, they'll be judged on a case-by-case basis and maybe generally how long they may be able to take one if approved. You just want to avoid a situation where someone goes out, and this can definitely happen during the pandemic, especially under kind of mysterious causes or reasons, and then end up on this indefinite leave. So you at least want to have a basic framework in your handbook of the process and the procedures for a leave of absence, so that if someone wishes to take one, you have some framework and you can set some boundaries. As you can imagine, we get a ton of questions about adding kind of COVID or pandemic policies to the handbook. While it's great and important to have policies around how the pandemic affects or is affecting your workplace, usually we recommend those to be more standalone policies, because they're very subject to change as government guidelines and restrictions change. And then also, while we hope we're out of the woods here, should another pandemic come along, the way that businesses wish to treat it or have to treat it could be very different. So great as standalone policies, but maybe not best for the kind of actual employee handbook itself. And then finally, big believer in standards of conduct policies, especially for folks in the transportation industry whose business relies upon customer service. Just kind of having a list of basic do's and don'ts, etiquette, things to not talk about with customers or clientele, expectations, guidelines. And it doesn't have to be an all-inclusive list, but so often when someone is being terminated for inappropriate behavior, it's great to be able to point to a specific policy in the handbook. And a lot of times there isn't that in there, so it just makes it kind of more of a performance-based termination, which makes it really difficult to win an unemployment case. But if you can kind of clearly say that they violated the standards of conduct policy, that at least gives you a leg to stand on. All right. So job descriptions. So I've mentioned it already a couple times in today's presentation, but job descriptions really are your first line of defense legally as an employer. They come into play in so many important ways. First of which is recruiting and interviewing. So really helps you give prospective employees a good understanding of what the job is, what the essential duties that they're going to be responsible for are, what requirements they might be, in terms of what skills or education or certifications they may need to have. It's also great to have physical requirements in there if there's going to be any lifting or bending or environmental considerations as well. They're also really crucial when it comes to classifying your employees. So if you're trying to make an employee exempt from overtime and paid on a salary basis or what have you, that has to be tied to one of the allowed Fair Labor Standards Act exemptions. So you really want those job duties to speak to the requirements of that exemption. Also ADA compliant. So as I said, if you have someone with a disability, the next step is that interactive process. And really the only way to do that effectively and compliantly is to be able to look at the job description and look at those essential functions of the job and go through those one by one and determine, are those something that the employee will be able to do, and if a reasonable accommodation needs to be made for them to do it. Also important for workers' comp cases, especially if you're looking for someone to come back to restricted duty, or they need to provide a fitness for duty upon returning to work. You really want that doctor or medical professional to be able to look at the job description, see what's expected of that employee, and then be able to share if there are going to be any restrictions based on that job description. Also big for defending unemployment claims, when you can really speak to the functions of the job that the employee was not able to do or violated. And then performance management. Job descriptions make performance reviews much, much easier and less contentious. When you're able to point to something, again, whether it's a review or a verbal warning or a written warning, it becomes a lot less debatable when you're pointing to the specific things that are in the employee's job description and where they're falling short. Rather than, you want to avoid the defense of, oh, I didn't realize you were expecting that of me, or I didn't think that was my job. Having it in the job description really addresses that well. The other area that I spoke to a little bit earlier about where these also are coming in very handy is with employees who want to work remotely. So if you have a job and conceivably it may be able to be done remotely, but you really don't want it to be, it's great if you can have language in the job description that speaks to the need to be in the office for one reason or another. Another thing that I'll say in the transportation industry especially, you do want to mention when a job is safety sensitive. So certainly operating a motor vehicle is a safety sensitive position. That comes in very handy when it comes to restrictions for any kind of drugs, whether it's marijuana or prescription drugs that may, inhibit someone's ability to operate a motor vehicle. It's really great and a huge help if you have mention in there of the job being a safety sensitive position, which would restrict them from being able to perform the duties of the job under the influence of certain medications or drugs. All right, hiring practices. So this is certainly a hot topic, something that people are struggling with. I know a lot of us are tempted to hire the first person that applies for a job. There are some kind of basic principles of hiring that are evergreen that you do want to be mindful of as you go through the process. So you do want to retain applications and resumes for 1 year just for audit purposes, and if there's a claim, that's kind of the statute of limitations on making a claim if someone feels they should have been hired but weren't. Your case will look a lot better if you have retained those applications for your argument. For those of you who do background checks, drug testing, there is kind of an appropriate time to do that. So you don't want to do those before a formal offer of employment has been made. But so basically you want to do it post-offer, pre-employment. So you want to phrase your offer letter in a way that says, we are offering you this job for this amount of money, everything else you want to mention, and then just say it's contingent upon successful completion of the background check, drug test, what have you. If something does come up in a background check that gives you pause or causes you to kind of change your mind, because of the Fair Credit Reporting Act, there are certain steps you need to take. Certainly get in touch with us. NELA members do have the ability to submit questions and inquiries through mp-hr.com/NELA. If you do run into the situation, you will want to talk to a professional. In most cases, what you need to do is put together a pre-adverse action letter, provide that along with a copy of the consumer report or the background check that details kind of the information, give them a chance to respond to that, and then depending on how that goes, if it's something where it's say identity fraud or identity theft, and you do want to hire them, all well and good, but if you do end up taking adverse action, there's then a follow-up letter you have to send to them. So there are some legal hoops you have to jump through if you are using background checks and taking adverse action. Reference checks are also a great tool that not enough employers use. Really what you're looking to do through these programs, whether it's background checks or reference checks or drug testing, is avoid what's called legally negligent hiring. So these cases are admittedly somewhat rare, but I think the transportation industry is more ripe for picking with these, where if the company could have, should have, or did know that an employee posed a risk to their fellow employees, to customers and passengers, whatever it may be, and still moved ahead with the hire, there have been cases where companies have been charged with negligent hiring because of the actions that employee then took. So I know there are all different types of motor vehicle checks through insurances and things like that, but if someone slipped through the cracks, operated a vehicle, and was driving under the influence and crashed and caused injuries to one of your passengers, and then it was found that this person had a long list of driving violations and arrests and DUIs and what have you, that could potentially be a case of negligent hiring on the transportation company's part. You also want to be careful with social media. So while there are things that you can find in social media searches that you would be allowed to make hiring decisions on, obviously you also can learn things about protected classes and other things that you wouldn't be allowed to make a hiring decision on. So tread very carefully with your social media searches of prospective employees. You may want to have a third party do it, or someone that is trained to simply and only report back the things that would be compliant to make a hiring decision on. So when it comes to those offer letters, a few tips there. You want to avoid any contractual language. You want to have your employment at will statement in there as well, just like the handbook, just to make it clear that the relationship can be terminated at any time or for any reason. You do want to state the salary per pay period. So rather than saying we're going to pay you $50,000 a year or $52,000 a year, you might say $1,000 a week, which annualizes to $52,000 a year. There have been some extreme court cases where an offer letter was perceived to be a guarantee for that 1 year salary rather than the per pay period amount. So definitely report it as a per pay period amount. You do want to also in the offer letter share the status of the job, whether it'll be non-exempt and subject to overtime or an exempt position, and then also that within 3 days of hire they're going to have to be able to adequately complete and provide documentation for the I-9 form, which we'll talk about in a second. When it comes to that interview process, some questions you want to avoid: anything about marital status, whether or not the applicant has any children. For national origin reasons, you want to avoid asking questions about where they were born or what their race or ethnicity is. With the ADEA that we talked about at the beginning, you want to avoid questions about age, or any questions that could be seen as fishing for age, like what year did you graduate from high school, what year did you graduate from college. And then for the religion protected class, questions about religious holidays that are observed by the applicant. In addition, you want to be careful about asking about child care arrangements. You want to just stick to the schedule for the job is, generally this. Is this something you'd be able to complete without any issue? Focus things on the job and not what the employee or potential employee circumstances are. You want to avoid medical conditions. Again, this is where the job description comes in handy. If you can show what the duties of the job are and then simply ask, are these things that you'll be able to complete with or without reasonable accommodation, that should be sufficient. You want to avoid asking questions about historical workers' comp claims, as well as how they plan to get to work. You can certainly confirm that they have reliable transportation to get to work each day, but you want to be careful with some of these questions. All right, next is I-9. So this is probably the most crucial hiring document you want to make sure you have completed and completed correctly for audit purposes. The Department of Homeland Security does go around and audit these. Worked with several employers, including some in the transportation industry, who have been subject to I-9 audits. So please do be sure that you have these done. So the IRCA that we talked about before governs the use of I-9 forms. You don't have to have them in place for owners, contractors, or volunteers, but any W-2 employees that you do employ, you do need to have an I-9 for. So on the first day, Section 1 should be completed. That's the portion completed by the employee. They then need to provide some documentation. And the forms of documentation and the purpose of the I-9 itself is to prove two things. A, the employer's, the employee's identity, and B, their authorization to work in the United States. So some things can prove both, a passport, for example. Otherwise, if they don't have one of those, what's called List A documents that show both of those things, they would have to supply one of each. So commonly, that might be a driver's license to prove identity, and then a social security card, or a birth certificate to prove their authorization to work in the U.S. Whatever it is, they need to supply that within 3 days of their first day, and then you as the employer need to fill out Section 2, which you're jotting down the information from the documents they provided to you, and then completing information about the person completing the form yourself. These forms then need to be retained for 3 years after their start date, or a year after they leave, whichever is longer. So just make sure you're following the retention guidelines there. When there is an audit, they do tend to look back a ways and verify against payroll records to make sure you have I-9s for everyone you should, even if those folks are terminated. It is also a best practice to keep your I-9s in a separate file rather than mixed in with each employee's personnel file. Just in case of audit, you want to just be able to pull that I-9 file and give that to the auditor rather than having them rifle through all your personnel records and seeing anything that you don't want them to or that they shouldn't. Some don'ts, some do's and don'ts. Don't ask applicants to complete the I-9 before you've actually offered them a job or they've accepted it. You want to make this part of the onboarding process. You don't want to tell them exactly which forms they should provide to you for their proof. So within the I-9 form, there's a list of acceptable documentation. You just want to give them that. You don't want to say, you need to give us a passport or you need to give us a driver's license. Any of those forms on that list are equally acceptable, so you don't want to be too specific there. If you see that the employee made a mistake in the portion that they need to complete, you just want to make sure that they make the correction and initial it. You don't want to make it look like you are filling that out or making any edits to the form as the employer on Section 1. So one common myth or misconception is that you have to keep photocopies of the documents that the employee provides. You don't. Some employers do, and that's fine. That can be a best practice. It's not necessarily a bad idea. But if you do, you just want to be consistent with it, if you do or if you don't. So either collect photocopies of those documents for everybody or don't do it for anyone, because it's very easy to look like you're being discriminatory if you're doing it for some and not for others. If an employee fails to be able to provide the necessary documentation, you should have them no longer report to work until they can provide it, because after 3 days, you're now on the hook and could be in violation. So you want to stress the importance of that and make sure you get that in within 3 days of their hire date. So exempt versus non-exempt. This is a hot topic, a touchy topic. There's been a lot of real controversy, I'd say, in the transportation industry as well, especially with drivers. And the taxi cab exemption and all that and where they fall, and the courts have gone back and forth. So I'll defer to the attorneys as they're more up to date on case law. The most recent case law that I know of with this is from 2019, I believe, and it was on an appeal, but they did feel that livery drivers and limousine drivers and things like that did fall into the exempt category, but there's a lot of back and forth on that, so it's really best to talk to a true legal attorney or legal counsel when it comes to classification of drivers specifically. But in short, the Fair Labor Standards Act sets the federal minimum wage. It sets overtime as time and a half for hours worked over 40 in a work week. It also sets the child labor rules, but does create exemptions. So for folks who have certain job duties, they can be considered exempt, which means not having to be paid overtime, not having to keep records of their hours worked, what have you. So non-exempt employees, meaning folks who do not fit into any exemption, they generally can be paid hourly, salary, day rate, job rate, piece rate, commission, what have you. The type of pay doesn't necessarily matter, but you do have to be keeping track of their hours, because at the end of the day, whatever hours they're working have to meet at least minimum wage. So even if you can pay someone non-exempt salary, but you have to be sure that they're either staying under 40 hours in a work week, or if they're not, that you're calculating overtime for them correctly. Exempt employees are generally paid on a salary basis. There are a few exceptions. If you have people who are doing outside sales, there's no minimum salary there. There are other exemptions, including some driving exemptions that don't have a salary requirement, but they do all have job duties that need to meet the levels of the exemption. So when you're classifying employees exempt or non-exempt, first you want to check the salary level test. And again, there are exceptions to this, especially in transportation. Then you, more importantly, want to focus on the duties test. So there are various exemptions. So for instance, an executive exemption would be someone who's supervising or managing others. If that's a primary portion of their job, they could very well meet the executive exemption. The administrative exemption is much more gray, but in that, if people are doing, white collar, clerical work, and they're able to have decision-making power for what's considered quote-unquote matters of significance. So if they don't need a lot of approval from management on somewhat important decisions to the business, then there's a chance for an administrative exemption there. And then there are several others as well: learned professional, outside sales, computer professionals. But if you have any questions on these, or think you may have people misclassified, or want some guidance on how to classify folks, feel free to reach out to us and be happy to walk you through that. Some things to avoid that can raise some eyebrows or red flags. If you pay all your employees as salaried, or consider them all exempt, it's somewhat rare at a business for every employee from top to bottom to legitimately be exempt. So you probably want to avoid that, or at least be able to justify it. Supervisors can be tricky. So there have been some big cases where assistant managers, like in retail and restaurants, kind of failed to meet the bar for that executive exemption that I mentioned. So you got to be very careful in terms of what their responsibilities are with that. You also, while job descriptions are a crucial part of the equation, you want to make sure that those job descriptions are true and accurate to what the employee is really doing on a day-to-day basis. Just because a job description speaks to an exemption, if that's not really what they're doing, or it's not focused in the right way, then it may not necessarily be legitimately an exempt position. You also have to be very careful. When someone is exempt, you have the benefit of not having to pay them overtime, but there's also a very limited list of when or how you're able to deduct from that guaranteed payment to those folks. So tread very carefully there. So should you have employees who are misclassified, the penalties can be severe. The federal government can go back 3 years and charge you with what they view as unpaid wages plus interest. If you're here in Massachusetts, violations of this are considered violations of the Massachusetts Wage Act, which automatically triple whatever the damages are. You can also be responsible for attorney's fees and court costs. And if they find that it wasn't just a mistake, that you were willfully violating the law, they can charge you criminally as well. You also have to be very, very careful with overtime in and of itself. So anyone who is non-exempt, you got to be tracking their hours, even if you're not paying them on an hourly basis. It's very important. You've got to keep records of that. If you're not keeping records of hours worked, again, even if you're not paying by the hour, then the Department of Labor will largely go by whatever the employee said if you don't have the paperwork or the documentation to prove otherwise. So you got to tread very carefully there. Again, the statute of limitations federally is 3 years, so make sure all of your payroll records and time cards or whatever you're using are kept on file for at least 3 years. So several categories can create slip-ups, especially within the transportation industry, things like on-call time, waiting time, meal and rest periods, training time, travel time, and sleep time. So things you have to be very careful of with your non-exempt employees. But again, if you have questions that pertain to this, feel free to reach out. The rules vary on each and sometimes vary by state as well in terms of what the requirements are there. So for instance, travel time, the federal definition, if you are requiring employees to travel to a conference or something like that, if those hours coincide with their normal working day, even if it's not a normal working day for them, so let's say I work Monday through Friday, 9 to 5, if my company is having me travel at, taking a flight at 10 a.m. on a Saturday, even though I wouldn't normally be working that day, because it's my normal, hours of the day, I'd have to be compensated travel time for that. Some other states, thinking of California, their travel time is much more loose, and there are many more situations where an employer has to pay travel time. So again, it varies greatly from state to state and situation to situation. So some more common overtime mistakes: just assuming management is not entitled to overtime. You really have to take a look at their duties. Are they 90% of the time doing the work of the others and 10% of the time sending people on lunch or things like that? That might not qualify. Again, assuming that anyone who's salaried is exempt, allowing employees to perform work off of the clock. Whenever you see a case hit where it's claimed that employees weren't paid properly or weren't paid overtime, there's always mention of working off the clock. And if you are audited by the DOL, a lot of times they will interview employees and this question will come up. You do want to pay overtime when it's due. Some people, especially if you're coming from the public sector, will be used to comp time or compensating with time off rather than actual time and a half overtime pay, but that is not allowed in private business. So you want to be very careful there and just pay the overtime. There's also what's known as the regular rate. So not just someone's regularly hourly rate isn't necessarily all that has to be factored into the time and a half. Sometimes there are other incentive pays and other forms of compensation that have to be factored in when an employee does work overtime. So again, consult an expert there if you run into this situation. You want to make sure you're being mindful of state and local laws, not just the federal ones. So again, the rules can vary greatly from state to state. If you pay bi-weekly, it's important to note you have to treat each week differently and separately. So if an employee, say, works 50 hours one week, you can't just have them work 30 the next and not have them be subject to overtime. It's 40 hours per week. So that employee would be entitled to 10 hours of overtime in that situation. Employers who do allow telecommuting have to be especially mindful of this. So it's not always as easy as when we're in the office together and you can see someone when they're working and when they're not working. You got to set pretty strict guidelines and expectations when it comes to people performing work when they're working from home, and that you only want them working when they're scheduled to be working, because they might be great people, but if things sour or there's a missy termination, all of a sudden they might think back to all those hours they put in and weren't paid for, and come looking for those. And then lastly, we just want to make sure everyone's mindful of workplace and sexual harassment, especially for companies who did have some element of remote work during the pandemic. We're finding that as people are coming back into the office and commingling again, sometimes they've forgotten their manners or forgotten, kind of how to act professionally. So you do want to make sure that all of your employees are educated when it comes to unlawful harassment. We do offer training, non-harassment training, both for entire employee populations as well as managers and supervisors. But it's just really important that you're doing all that you can as an employer to avoid any potential claims of sexual harassment or discriminatory harassment. So aside from sexual harassment, you can also have instances of legal harassment when someone feels they're being harassed based on their protected classes. So those things we talked about at the beginning: their religion, their national origin, their sex, their gender, sexual orientation, things like that. And as a business, again, kind of like the other stuff we're talking about, if you know or should have known that harassment was occurring, you are liable. So if someone comes forward and says they're being harassed, it's really your duty to conduct a full investigation and see that through. If you are a transportation company here in Massachusetts and you have 6 or more employees, you are technically required to have a policy against sexual harassment, and you do need to have that distributed at least once a year. So again, some best practices here: implement a strong policy prohibiting harassment, provide annual training to your employees. So because you have to distribute the policy once a year, it's a great time to also do a little bit of training. And then again, even if you think someone's making a mountain out of a molehill, it's important that you take that seriously and you do conduct an investigation. Ultimately, you might find that harassment didn't occur. That happens quite often, but you do want to take it seriously and avoid people kind of either going to attorneys or going to the Mass Commission Against Discrimination or the Federal Equal Employment Opportunity Commission. All right. So that is today's presentation. I do want to thank everyone for joining us this afternoon. If you do have any questions, whether it's related to today's presentation or any other HR related questions you may have, again, NELA has its own website set up. It's mp-hr.com, like you see on the screen there, and then just /NELA. And those inquiries will go right to our inbox, and we'll be happy to respond to you and help you out. But as always, thank you so much for joining our monthly webinar series, and we look forward to talking to you again soon. Thank you so much.